Part 3 of the discussion on law on agency. This will cover the chapter 2 of the law on agency, which is the obligations of the agent. Okay, we start with Article 1884. So this article provides for the duty of agent to carry out the agency. Okay, an agent who does not carry out the agency is liable for damages. So, upon the other hand, if he fulfills his duty, he is not personally liable unless he so binds himself. Okay? So, ang article na to, ang sabi dito, okay, ang agent daw ay may duty or may obligasyon, okay, to carry out or to fulfill his duty as an agent. Okay? Kung na-fulfill niya yung duty niya as an agent, hindi siya magiging personally liable or hindi siya magiging liable for any damages. Okay? Except, okay, there's one instance provided by law. Okay? Unless he so binds himself. Okay? On the second paragraph of this article, you can find there the effect of principal's death. Okay? Paano pag namatay yung principal? Okay? Let's cite an example. Okay? Angelo was Peter's agent. Okay? Angelo was performing a business of the agency when suddenly Peter died. Okay? Although as a rule, the death of the principal extinguishes the agency. Kung mababasa nyo sa modes of extinguishing agency, yung death of the principal, okay? Here, Angelo is obliged, okay? Angelo is still obliged to finish the business already begun if delay should entail any danger. That is provided in your Article 1884, the paragraph 2. Another instance naman. What is the effect if the agent, okay, sells the thing to himself? Paano kung ibebenta niya yung bagay or yung thing na under his care? Okay? In the case of Barton versus Leyte Asphalt, the Supreme Court said that, okay, an agent who has been authorized to sell some merchandise is not allowed to bind the principal by selling to himself, okay, directly or indirectly. Hence, if an agent, through his own sub-agent, buys from the principal is not required to fill such orders unless said principal ratifies the sale after he had full knowledge of the facts of the case. We go to Article 1885. Okay? In your Article 1885, you can find there the rule if person declines the agency. Anong mangyayari pag the person declines the agency? Okay? Under Article 1885, the rule is that a person is of course free to refuse to be an agent. Okay? Ang isang tao daw, pwede daw po siyang, okay, maghindi o kaya hindi niya i-accept yung duty or obligation as an agent. Okay? However, equity demands the rule set forth in the first sentence of this article, which is, in case a person declines an agency, she is bound to observe the diligence of a good father of a family in the custody and preservation of the goods forwarded to him by the owner until the latter should appoint an agent. So, for example, in-appoint ni Pedro si Angelo as his agent. Pero si Angelo ayaw niyang maging agent. Okay? Kung may iniwang bagay or merong merchandise or goods under the care of Angelo, okay, which is owned by Pedro, okay, or Peter, Angelo, okay, has the duty or is bound, okay, kahit tinanggihan niya yung or ni-refuse niya yung agency, okay, Angelo is still under the legal obligation, okay? But legal obligation because it's provided by law, okay? Legal obligation to observe the diligence of a good father of a family in the custody and preservation of the goods. Okay? So, what is the duty of the owner? Okay? In here, in Article 1885, okay, the owner must also act as soon as possible. Okay? So, yung principal na may-ari ng merchandise, di ba, hindi nga tinanggap nung tao, yung agency, okay? Meron daw siyang duty. Okay? What is this duty? Number 1, to appoint an agent. Okay? Okay? And also, he has the duty to take charge of the goods. Okay? He must do these duties as soon as possible. Next, Article 1886. Okay. Article 1886 talks about the stipulation for agent to advance necessary funds. So, example, Ara is Pedro's agent. Okay? Both agreed that Ara would advance the necessary funds, but later on, Pedro became insolvent. So, wala na daw kapera-pera si Pedro. Okay? Is Ara still bound to furnish such necessary funds? Si Ara, required pa rin ba siyang mag-advance ng funds? Gumastos ng funds kahit wala ng kapera-pera yung principal? The answer there is found in your Article 1886. Okay? Okay, according to the court, the answer there is, okay, Ara is has no obligation anymore to furnish such necessary funds in view of principal's insolvency. Okay, we continue. Article 1887. In your Article 1887, this talks about the duty, okay, of the principal to make the instructions to agent clear, okay, and the duty of the agent to follow instruction. So, in here, okay, according to this article, okay, Article 1887, if the agent strictly followed the instructions of the principal, he cannot be held responsible for the failure of his principal to accomplish the object of the agency, unless the said agent exceeded his authority or has acted with negligence, deceit, or fraud. So, according in this article, kung sinunod lang daw ni agent yung instructions ni principal, okay? Kung ano yung instruction mismo ni principal, yun ang finalo niya, okay? Hindi siya magiging liable. Okay? He cannot be held responsible. However, if magiging liable siya in case number 1, pag sumobra siya or exceeded his authority, and number 2, pag merong negligence, okay? Merong deceit or fraud on the part of agent. So, how are we going to construe the instructions given by the principal? Ang sabi po sa batas natin, ang instructions are to be construed, okay, as a plain man acquainted with the object in view and attending reasonably to the language used has in fact construed it. Okay? Accordingly, he is not bound to take the opinion of an attorney. Hindi mo daw kailangang pumunta sa attorney to understand the instructions. Okay? Concerning the meaning of the word not technical and apparently employed in the popular sense. Article 1888. Okay? This article talks about an instance when agency should not be carried out. Okay? Accordingly, in this article, okay, an agency or the agent shall not carry out an agency if the execution would manifestly result in loss or damages to the principal. In simpler words, okay, kung ito daw ay magkokos ng damage or loss sa property or anything that has something with the principal, okay, the agency should not be carried out. Bakit hindi na i-carry out, ma'am? Okay? The simple answer is, okay, agency is always carried out for the benefit of the principal. So if it is for the loss or the damage on the part of the principal, of course, agency should not be carried out. So, let's give an example. Okay? Pedro instructed his agent, Angelo, to charter a boat from Japan to Manila and to load the principal's good with the specific instruction to sail from Japan to Manila on February 14, 2021, and to thereafter sell the goods upon arrival in Manila. The weather report on that date of the scheduled departure showed that a strong typhoon was directly going to cross the path of the boat. Considering the circumstances, it would be safe to sail only after 1 week. Okay? So, hindi daw pwede on February 14, 2021 kasi may parating na bagyo. Tapos yung bagyong yun is dadaan doon sa ruta ng barko. At safe lang daw ang magbiyahe, okay, only after 1 week. So, in the meantime, the prices of the goods at Manila went down by 50%. Okay? Pedro thus fell short of the profits he expected to realize. Would Angelo, the agent, be liable to Pedro? The answer there is no, because Angelo would not be liable to Pedro because had Angelo carried out the agency, it would have resulted in loss or damage to his principal, Pedro. So, next, we proceed with Article 1889. So, in your Article 1889, this talks about the rule if the agent prefers his own interest. Yung sariling kabutihan ni agent ang iniisip niya. Okay? Sabi ng batas, the agent will be liable for damages if there being a conflict between his interests and those of the principal. He should prefer his own. Okay? So, let's take an example. Pedro owns a Toyota car model 2020. He appoints Angelo to sell the car. Angelo is also an owner of the same Toyota car, the same ang itsura, the same ang style, ganyan. Pero syempre magkaiba ang plate number kasi magkaiba naman ang sasakyan. The same lang yung description or the model type ng sasakyan. The same na Toyota. Let's say Toyota Fortuner, okay? Yung kay a principal, okay, color black, yung kay Angelo, color white. Okay? So, Nico, a third person, is interested in buying either Pedro's car or Angelo's car for 3 million. Which is, of course, very attractive price. Kasi the selling price lang ata ng Toyota Fortuner is nasa, I'm not sure, pero nasa 1.7 million. Okay? If, in this case, okay, based on Article 1889, if Angelo sells his own car and not that of Pedro's car, okay, si Pedro, pwede niyang kasuhan si Angelo for damages, for it is clear that Angelo has preferred his own interest. So, in your Article 1889, ang sabi, okay, kung iunahin niya ang sarili niyang pang-interest and there is a conflict, kailangan may conflict then the principal can sue, okay, the principal can sue the agent. Okay, we proceed with Article 1890. If the agent, okay, in your Article 1890, this talks about the authority to borrow or lend money. Okay? In your Article 1890, the authority to borrow or lend money. Paano daw this authority to manghiram ng pera o kaya magpautang ng pera. So, let's take an example. Angelo was authorized to borrow money. So, na-authorize daw si Angelo na umutang ng pera. Can Angelo, okay, lend his own money to the principal? Pwede bang magpautang si Angelo ng sarili niyang pera sa principal? The answer there is yes. Why? Because the principal suffers no injury. Next, another example. What if Angelo has been authorized to lend money at interest? Okay? May Angelo borrow the money for himself? The answer there is no. Okay? Unless the principal consents thereto. What is the reason? Okay? In here, the agent may not be a good borrower or he may be insolvent. Pwede daw siyang hindi maayos na magbayad. Okay? Baka siya yung tipo ng tao na, bukas hanggang sa wala na. Yung bukas niya naging bato. Okay? Kaya naman siya yung taong wala na palang pera pero utang ng utang. Okay? In here, there is a danger, okay, on the interest of the principal. Okay? So, he is not, the agent cannot borrow the money for himself. 1891. Okay? In your 1891, this talks about the duty of the agent to account. Okay? Let's take an example. Si Ara is an agent. Okay? Si Ara, she did not reveal to her principal, Pedro, na meron siyang profit doon sa transaction na connected si Pedro. Okay? Cover siya ng contract of agency nila. So, Ara, okay, did not reveal to her principal that Ara was able to obtain a secret profit from the transaction in the nature of bonus, gratuity, or personal benefit. Question: does she still have the right to collect the commission that ordinarily should be due to her? Okay? Diba nga, meron dapat siyang commission bilang agent kasi successful yung transaction. Dito sa case na given, okay, kinupit niya yung profit. Ang tanong ngayon, meron pa rin bang karapatan si Ara mag-collect ng commission niya? Okay? The answer there is no. Okay, the Supreme Court decided this in the case of Domingo versus Domingo, 42-131. Okay? According to the Supreme Court, no more on account of her breach of loyalty to the principal. Okay? The forfeiture of the commission will take place even if the original party does not suffer any injury by reason of such breach of loyalty. It does not even matter that the agency was a gratuitous one or that the principal obtained a better result. Okay? Or that the usage or customs allowed to the receipt of such a bonus. Indeed, in this case, an agent has an absolute duty to make a full disclosure or accounting to his principal all the transactions and material facts that may have some relevance with the agency. So, in the given case, wala na pong karapatan si Ara na mangkolekta pa ng komisyon niya. Bakit po? Kasi there is a breach of loyalty on her part. Okay? We go to Article 1892. This article talks about the appointment of substitute for the agent. Okay? Let's take an example. Ara is Pedro's agent. Okay? In their contract, nothing was mentioned as to whether or not Ara could appoint a substitute. So, Ara appointed Sheila as her substitute. Is the appointment of the substitute valid? The answer there is yes. This is indicated in your first paragraph of Article 1892, which states that, okay, the agent may appoint a substitute if the principal has not prohibited. Okay, in the case, hindi naman na-prohibit, diba? From doing so, but he shall be responsible for the acts of the substitute. Okay? So, in here, Ara shall be responsible for the acts of the substitute, Sheila. Okay? Next question. In the previously given question, suppose that the Sheila, the substitute, violated the instruction of the principal. Whom can the principal hold liable? The answer there is principal can hold the agent, which is Ara, liable, okay, as indicated in Article 1892, and the principal can also hold Sheila as liable as provided in your Article 1893. So, si principal, okay, pwede niyang i-hold liable si agent at saka yung substitute. Another question. Ara is Pedro's agent. Ara asked Pedro for the permission to appoint a substitute. So, humingi si Ara ng permission from principal to appoint another agent. Or, sorry, to appoint a substitute. So, parang kumbaga kung just in case hindi maka-perform si Ara, may magsa-substitute sa kanya. Okay? Humingi daw siya ng permission from the principal. Okay? However, okay, but Ara did not mention who the substitute would be. So, hindi niya minention kung sino ba. Okay? So, eventually, the principal still agreed. Now, the substitute violated the principal's instruction as well as Ara's instructions, causing damages to the principal. Can principal hold Ara liable for the substitute's actuations in case, for example, the substitute is insolvent? So, the answer there is, it depends. If the substitute appointed by Ara was at the time of appointment notoriously incompetent or insolvent, then of course, Pedro can hold Ara liable subsidiarily or even primarily. Okay? If the substitute at the time of appointment, hindi naman daw po siya notoriously incompetent or insolvent, then P can only hold liable the substitute. Okay? He cannot hold Ara liable either primarily or subsidiarily. Another question. So, another instance, Ara is Pedro's agent. Ara was prohibited by Pedro to appoint a substitute. So, hindi pwede. Dapat si Ara lang. Okay? Sabi ng principal. Nevertheless, okay, Ara still appointed a substitute. So, let's say Sheila is the substitute. Sheila sold goods belonging to principal to the buyer Benito, who was a purchaser in good faith. Is the sale valid? The answer there is no. Okay? The sale is completely null and void. Why? Because the law says that all acts of the substitute appointed against the prohibition of the principal is void as provided in the last paragraph of Article 1892. In your Article 1893, this talks about when the principal can sue the substitute. Okay, naibigay ko na. So, kindly go over na lang yan. Then, we proceed with Article 1894. In Article 1894, it says that the responsibility of two or more agents, even though they have been appointed simultaneously, is not solidarily if solidarity has not been expressly stipulated. So, in here, remember na ang liability po natin is joint, okay, not solidarity. Anong ibig sabihin ng joint? Kung anong kasalanan mo, okay, yun lang ang kasalanan mo. Hindi mo kasalanan yung kasalanan ng ibang tao. So, for example, okay, si A and B are both agents. Okay, they are appointed simultaneously. Nagkamali si B, let's say may violation si B, si A hindi pwedeng maging liable doon sa violation. Why? Because wala naman siyang kasalanan. Okay? The liability of B must be solely on his part, okay, and not to include A. In your Article 1894, it talks about the liability of the agent towards the principal and not towards third parties. Okay? In here, the liability is joint and personal. Okay? Kakasabi ko lang kanina, hindi pwedeng maging kasalanan ni A yung violation ni B kasi nga, joint ang liability. Okay? But only if each can act separately. Separate act dapat siya. But if it be essential that all agents should act and one is unable to do so, then the one is the only agent liable. We proceed with Article 1895. Okay? This talks about the when solidarity has been agreed upon. Okay? Diba, kasasabi lang natin na joint and personal ang liability. Okay? Sa Article 1895, nagsasabi kung kailan nagkakaroon ng solidarity ang liability. So, example, Pedro appointed Ana and Benito as agents. Okay? Solidarity between the agents was agreed upon. Okay? Na ngayon, may violation or may fault si Benito. The agency was not fulfilled. Okay? Can Pedro sue A for damages? Okay? The answer there is yes. Okay? If Benito acted within the scope of his authority, Ana, being the solidary agent, can be made responsible for the entire damages without prejudice, okay, to her right later on to recover from the erring agent. Article 1896 and 87, kindly read na lang yan, okay? In your Article 1896, it talks about the liability of the agent for interest. Sabi dito, the agent owes interest on the sums he has applied to his own use from the day on which he did so and on those which he still owes after the extinguishment of the agency. Okay? So, this article is without prejudice to the criminal action that may be brought because of conversion. On the other hand, there is no liability for interest on the sums which have not been converted for agent's own use, unless, of course, at the expiration of the agency, the agent still owes the principal certain amounts or certain sums. Okay? In your Article 1897 naman, this talks about the no personal liability for agent. Okay? The reason of the law, okay? The said agents who act as agent does not represent himself but the principal. Okay? So, in case of acts where the agent is in excess of authority, the principal cannot be bound unless he ratifies the act. And also, if an agent obligates himself personally, aside from acting in behalf of his agent, both are bound. In your Article 1898, this talks about the contracts entered into in excess of authority. Okay? Mga kontratang pinasukan ng parties na tapos sumobra sa authorities agent. Okay? This article refers only to the liability of the agent towards third person. Okay? So, it is clear that under the premises given, the principal is not bound at all. Syempre, kasi nga sumobra siya ng authority si agent. Okay? Except only if there is a subsequent ratification by him. Therefore, the status of the contract here is void. Okay? Void or inexistent. It only refers to the tie between the agent and the third party. With regards to the principal, okay, it can be ratified. Okay? In your Article 1899, this talks about the effect of agent's ignorance. No, ignorante daw yung agent. So, in this article, it is based on equity. For after all, the agent had complied with his duty. So, it is the principal's fault, okay, or still the principal is responsible should he have appointed an ignorant agent. Okay? Equity demands that principal should be made responsible. 1900, okay? This talks about the act performed within the terms of written authority. So, let's just give an example na lang. Pedro gave his agent Ana a power of attorney, wherein, okay, there was a stated provision where Ana has the right to sell the parcels of land belonging to Pedro. Okay? Let's say the land is located in Tanza and Cagcay. Here, Pedro and Ana, okay, however, had an understanding to the effect that Ana should only sell one parcel of land. Okay? So, nasa special power of attorney, dalawang lote ang nakalagay doon, Tanza and Cagcay. Pero sa kanilang dalawa, ang mutual understanding nila is isa lang dapat ang ibebenta niya. Okay? Ana subsequently sold both, dalawang na ibinenta niya. Okay? Pedro did not ratify the contract. Okay? Is Pedro bound by the sale of both parcels? The answer there is yes. Okay? While it is true that a third party deals with an agent at his own risk, and while it is the duty of the third party to investigate the extent of an agent's authority, in this case, the power of attorney as written showed complete authorization. It is unfair to demand that the third person to inquire further than the terms of the said power of attorney as written. To hold otherwise would be to open the door to countless fraud and machination. So, ibig sabihin nito, since it's clear from the special power of attorney that Ana or the agent is allowed or is authorized to sell two parcels of land, which is Tanza and Cagcay, it is clear from the written authority, okay, that he can sell this. So, the buyer has under no obligation to inquire further than that the terms provided for in the special power of attorney. Also, okay? Also, the special power of attorney is already a complete authorization. So, Article 1901. What is the effect of ratification? The effect of ratification, there are two. Ratification in effect grants authority to the agent, and also it is to note that the ratification may be made in the future. Ang ratification, nangyayari lang po yan in the future, hindi pwedeng pass yan. Okay? Next. Teka. Tingnan natin kung So, in your article 1902, this talks about private or secret orders. In here, private or secret orders and instructions of the principal do not prejudice third persons who have relied upon the power of attorney or instructions shown to them. Kindly read the case of Cruz versus Court of Appeals, GR number 85685, September 11, 1991, to further understand this article. Okay? So, remember na, note that innocent persons are not to be prejudiced. So, in your article 1903, who is a commission agent? Okay, a commission agent is one which the commission agent must be a merchant or a broker. Okay, the agent having the option of acting in his own name or in that of the principal. So, what is the difference between a commission agent and a broker? A commission agent is one engaged in the purchase and sale of principal of personal property, which for this purpose has to be placed in his possession and at his disposal. He has a relationship not only with his principal and the buyers or sellers, but also with the property which constitutes the object of the transaction. Ang broker naman, okay, on the other hand, maintains no relationship with the thing which he sells or purchases. He is supposed to be merely a go-between and intermediary between the seller and the buyer. As such, he does not have either the custody or the possession of the thing that he disposes of. Okay? His only function is to bring the parties to the transaction. This definition is provided in the case of Pacific versus Yatco 68 Phil 398. Okay? Kindly read 1904, the article which provides for the duty of commission agent to place countermarks. And lastly, article 1905, which talks about the sale by the commission agent on credit. Okay? Hindi daw po cash. So, let's take an example. Ara was Pedro's commission agent who was asked to sell Pedro's car on cash. Ara sold it on credit. What are the rights of Pedro? Okay, the answer, Pedro may demand from Ara payment in cash. On the other hand, Ara shall be entitled to any interest or benefit which may result from such sale or credit. In here, remember that the principal is given two choices. Number one, that is to require cash or to ratify the sale on credit. Okay? In requiring to pay in cash, okay, if this is done, the principal should not be allowed to enrich himself at the agent's expense. Okay? If he chooses to ratify the sale on credit, the principal will have both the risk and the advantages. Article 1906. This talks about the duty of an agent to inform the principal. In this article, an authorized sale on credit may be treated as one on a cash basis. Okay? In this article, it only talks of the relationship between the commission agent and the principal. Okay? The third person should not be prejudiced. What is the reason of the law? Okay, according sa batas, to prevent the commission agent from stating that a sale which was in cash in reality was made on credit basis. So, Article 1907 and to 1909, kindly read na lang yung kasi it's all about the duties naman. Okay, so, that ends the discussion on the duties of the agent. Okay? Thank you for listening, and I hope you learned something for today. The last discussion will be all about obligations of the principal. So I think the book of the late Edgardo Paras, okay, as my basis for this discussion. Thank you for listening and have a nice day.